Join former FBI senior forensic examiners Becky Passmore and Stacey Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths, these badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacey's obsession, this podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Hey everybody, welcome back to another episode of Parsing the Truth, one bite at a time. I am your co-host, Stacey Eldridge, and as always, I am joined by my co-host, Becky Passmore.
Yes, welcome back everyone. We are going to jump right back into the testimony where Stacey was talking about her very first expert testimony after being trained in the FBI, going through all the training and then doing a pretty large case where introducing many exhibits and many pieces of digital forensics and evidence. As we ended the last episode, we were talking about the government resting in the case. So the government is done presenting the artifacts, the government is done presenting the evidence and the exhibits. And so now we're going to go into the unknown cross-examination of the defense.
Yes. Now, I am going to interrupt for a minute on two different points. So point one is that this is part 3 of my testimony. So if you haven't listened to the first 2 episodes, go back and do that so you don't miss all the foundational stuff that I spent over 100 pages of transcript talking about in the trial. Don't worry, I don't read 100 pages in the previous 2 episodes. We've kept it brief. And then if you are watching, you can see that Becky and I are matchy-matchy with our Parsing the Truth shirts. Very excited about that. And if you would love to have one, don't worry, we're going to hook you up because we're working on getting some merch of our podcast logo, of course, but some other merch that digital forensic examiners might want to actually wear. So keep your eyes peeled for that. But speaking of going into the unknown, I keep getting that Frozen song stuck in my head. I have kids. I will spare you singing it, but that is what my mind is singing as we start jumping into this part of the episode.
And I would say that it is the unknown. It truly is when that defense attorney gets up there to start that cross-examination. There were times I would hold my breath and hope and pray that they didn't have anything to ask me. And sometimes that worked. And sometimes it didn't. So let's get in and see how it worked for you, Stacey.
It starts off again about the emails because this is fundamental to the case. So he's asking me about the email strings again, the email messages, asking about why we chopped them up into separate exhibits and where we found them. He's asking about that all over again. Then he asked me to clarify that I was referring to the user of the computer when I was testifying. I was always saying the user of the computer. I never said the defendant that did this. I never said the defendant's name did this. I just said the user of the computer. And he was asking me if the user, that word user, is the correct term to refer to that person. And he asked if by person, if I meant it was a person that had sent the emails, that a person has to be punching in the information to send those emails. And then he asked me if I can state who the human being was that used that computer.
And that's because he's trying to get you to say that the defendant is the person whose butt is in the chair in this case.
Well, that's what we would like to do, right? But I think he's trying to get me to say that I couldn't put the defendant's butt in the chair.
Okay. Yeah.
So, because apparently I couldn't do that because I kept just saying the word user.
Right. And again, it goes back to being able to profile a user and their activity and the information that you're identifying on the computer that matches their activity on the computer. And we don't ever speak about someone's butt being in the chair, but we speak about the user. And if that is all reflecting back to that defendant, that is assumed who the user is.
Yeah, and sometimes in some cases we can get really good information because there's a lot of activity going on the computer that gives strong evidence that it was the defendant's butt in the chair while all of this was happening. And that has, you do your timeline analysis and you're seeing what is happening. Stuff we can do to do that is different user accounts being logged on to doing things that only the user would do, stuff of that nature. And so I don't know if I just didn't do it. I wouldn't have expected that I would have skipped over something like that, especially since we spent so much time going over the headers and the IP addresses and tying that all back to what his ISP provider said. So I think there just wasn't enough activity based on my testimony. It seems like to me, maybe he was just like in and out, did the deed and got out. I don't know.
Sure. So were there any more questions?
He asked if I had the defendant's IP address in the email he received. And I said no, because he was, and then I got cut off. And then I was directed to answer yes or no only.
Yeah, they cut you off sometimes, right? And that is because they're trying to keep you from stating something they don't want to be heard in the courtroom.
Yeah, they want you to not hurt their narrative, certainly. And again, that's interrupting your flow. You want to give a good answer because you want to explain things. That we're explainers. If we're not explaining, what are we doing here, right? And so they just cut you off. So it's always like, you might start off with yes or no, but you want to be like, but, no but, and they always cut you off at the but every single time when you try to go on and explain. Because you're trying to just get the facts out there, lay it all out there for the jury to make those decisions.
And they want it to be a literal yes or no answer. And many of the questions that are asked cannot be just explained with a yes or no answer.
Yes, very rarely is it yes or no, other than did you do this or not? Yes or no.
Exactly. So then what happens?
So he's backtracking all the way back to creating the images of the computers and the laptops. He's asking me about what files are the recycle bin and who deleted them. And then, of course, the answer is, who deleted them, whoever the logged in user was. And he asked me when they were deleted. And I was completely dumbfounded that I didn't know. I just said that info is in my report, but apparently I didn't think it was in my notes, so I didn't ask if I could look at my notes. I was just like, it's in the report. I don't know. Lost my mojo there.
Right. And he was probably thankful that you did and was looking at that as a win-win for him.
Yeah, for sure. And he's taking a moment here to review his notes, and he comes at me with this next question. And my memory of it, and it's very strong because it was my first time testifying. And I just had this feeling that he was very aggressive. So he very, very aggressively goes up to me and after he's looking at his notes and he goes, "Did you go to the system registry on the Power Pro laptop?" And I feel like he's trying to catch me to say that I didn't do something. Like he assumed I never would have reviewed the registry files.
So what was your answer?
Yes, I did indeed look at the system registry files. Although I think I only said yes.
Which then you probably threw him off of his mojo. So then what did he ask?
Then he asked if I produced a report and if I provided it.
And did you?
I sure did. Honestly, when I was looking at him, I felt like he looked a little disappointed.
Again, they are in a mode and a move to try and catch you off guard, right? And I've been sitting on that stand where they do come at you very aggressively, and our normal reaction is to go right back at them, but we can't do that. Then what happens?
So now he's trying to get me on the Dell.
And did he get you?
Nope. I disappointed him again by saying, yes, I had examined the registry files.
Where do you think that line of questioning really, truly came from?
I don't know, especially since he was so aggressive. Maybe he heard of it as this cool new thing that most forensic examiners weren't doing yet in some sort of like legal continuing education class. So he thought he would throw that at me.
Yeah. So did he try any more gotcha questions?
No, not really. He just maybe go back through the exhibits and confirm all of them. And then he asked me about the deleted dates present on the exhibits. And I answered that that wasn't the purpose of those exhibits, so they're not present. And then we just kind of jumped backwards into sending emails again and how to send emails and the fact that you need a username and password for emails to be sent. And he asked me if I knew that if he knew like my username and password, could he send emails? And so we talk about that, yeah, if you have a username and password, you can send emails. And then he asked me if it's a false record because somebody uses your username and password when they send the email. And I say, I'm not sure that I would call it a false record. And then he's trying to ask more questions about the false record. And so it's just kind of one of those things where we're going back and forth and we're not getting anywhere. And then the judge tells him to use a different word. And then he asks if I remember talking about an email from 5:30 a.m. And I say, I don't. And so that was it. That's the end of the cross-examination. And it's funny because going back through and reading it, and when I read about the gotcha part, it really didn't come off that way. I mean, it's just words, but I remember how it feels 20 years later when he like came at me with that question trying to get me.
Sure, yeah, I can understand that too. And so at this point, the questioning ends, and does the prosecutor do any redirect?
Sort of.
Yeah.
He
Just kind of, sort of.
just a little bit. He just has basically follow up on the fact that I'm going to have to bring some data back the next day, print out like hundreds of pages to bring it in to support the exhibits. And that was just related to the email string stuff and then the deleted dates and times of those files in the recycle bin.
Wow. So at this point, is there anything you wish you would have done better or differently?
Well, I think I wish I would have known how to pour water from a carafe in a courtroom in front of people.
That is one thing they did not teach us in FBI moot court.
No, they never mentioned about like drinking water on the stand and how to do it. I mean, shouldn't that have been like a 4-part class, 4 hours long or something like that? I don't know. It seems very important to me.
Absolutely. And along with where you're supposed to sit in the courtroom and how you're supposed to walk in the courtroom.
Right.
Yeah, I understand that.
Right.
So are you indicating you now know how to pour that water from a carafe?
You know, I'd still say it's hit or miss, but 20 years later, they tend to give us bottles of water. Thank God.
Right, exactly. That's right. So at this point, you've finished your testimony.
Mm-hmm.
You get dismissed from the stand. And then do you recall how long the trial went on? How many more witnesses were included in this?
I think a lot of the witnesses had went before me. I came on after lunch. Did I mention that? I swear to God, I always have to come on after lunch. It is no fair. Every time after lunch. And then there was one more witness after me, a quick one that day. And I think that was maybe the end of the prosecution side. And then the defense would have went on with their direct.
Okay. Right. Do you remember, did they bring a defense expert in to also talk about the digital evidence?
Nope, there wasn't any record of that.
Okay. And
that was pretty common 20 years ago. Let's be honest.
Yeah, absolutely. Very common 20 years ago. Maybe one day I'll tell you about my first defense expert. But yeah, very interesting. So do you recall how the case was found in? The end result of the case was?
Yeah, he was found guilty of these charges. So,
yeah.
And then it went through appeals and all of that stuff, but I don't believe I saw anything that any of it was changed.
Okay. So we've talked about your expert testimony. We've talked about getting exhibits into the courtroom. We've talked about aggressive behavior from some defense attorneys. Not all defense attorneys are like that, but some aggressive behavior by them.
Well, I will say you can also if you're on the other side, you can also get an aggressive prosecutor. So it can go both ways, regardless of where you're sitting. Basically, the opposing person can be aggressive with you.
Absolutely. Whether you're sitting for the defense or the prosecution. Absolutely. That's correct. So with that being said, and knowing that you went through the FBI training, and then we were very fortunate to go through a very strict and well-versed and well-prepped FBI moot court for our final project to get certified. Would you say that that process really prepared you to do your best in this trial?
It did, because we worked this big case start to finish, and we knew we were going to have to go testify on it. And so we were really just like prepping in terms of knowing the data inside out. And I think what helped me was I got a note back, like after on my graded thing, like, you could expect to have a really hard time on the witness stand. And I was like, woohoo. Did they write that on everyone's, or was it just mine?
Didn't write it on mine.
Well, so Stacy did not do as good as Becky in her final project and was told to expect a hard time. So like I had that note and I'm like, holy crap. And whoever is not testifying can go in and watch you. There's several courtrooms going in there, but it's a big event. So you can expect 25, 50 people to like be watching you testify at any one point for sure. And so it was good to know, just to like, the fact that it's important to become super familiar with the data, to have good notes, because that's the only thing you can look at when you're up on the stand. And then I went through the motions of doing prep with the attorney. And then afterwards, in front of everybody, they were like, the attorneys go, this is what you did good. This is what you did not so good. And they just break it down all for you. And then even afterwards, like they pull you aside and you have some more one-on-one stuff. So I think going through that really gave me the sense of how this is going to go down in real life. So I wasn't walking completely blind into my first testimony. Like I knew some of this stuff was going to happen. So that relieved that level of nerves, other than just the actual execution of testifying in a courtroom.
Right. And you felt like you've been there before. You felt like, I went through this in my training. I feel comfortable because I'm prepared. My prosecution has prepped me.
Yep.
Yeah. And I would also say that digital forensic examiners that got to go through and complete a true FBI moot court with prosecutions acting as defense attorneys and prosecution
they like to flip roles, right?
They did like to flip roles, and they really did a phenomenal job prepping us. They did a phenomenal job in preparing us for, first, what they call to be probably your worst testimony ever, because they're trying to unnerve you, because they don't want you to become unnerved in real testimony. So I was just hoping that your training from the FBI moot court actually helped you be, a great testimony giver here, because it appears that you did a very well-versed execution of being able to testify in court as an expert witness.
Yeah, and I think it went pretty well, especially considering how much just like introductory like keyword stuff I had to go over. So it's just like foundational, and then we're going over the emails over and over again. And then I think some of what gets confusing too is when the defense does it, they're kind of stream of consciousness to a certain extent. So there's a little bit of the jumping back and forth. You have to be able to track with that, and you have to be able to explain it in such a way, maybe draw in other references so you can keep the jury up to speed of where we're at.
That's right. And it's always seems that that is the most challenging part. And again, it goes back to the opposing counsel, because you have somewhat prepped with the attorney that you're testifying for, and then you don't know what the defense strategy is going to be. You don't know if they're going to try to muddy the water with confusing artifacts and evidence and terminology to where they trip you up. There's a lot of challenges, and it becomes a very unnerving situation, but you just have to stay calm in the matter. Do you feel like you stayed calm during your testimony when defense was asking you questions?
Yeah, I did feel pretty calm. Certainly nervous, but I didn't feel like I was being attacked or that I had to go on the attack. And, I think we could probably just do a whole separate episode, but talking about, how to deal with aggressiveness. And like we've mentioned, it's all dancing, because you don't want to respond back in kind and be so aggressive. But I've also had later experiences where I was like, I did just kind of fall. And I think they're working to get you to do this. They get you to fall into that yes, no, yes, no. And then you just stop and don't even try for the yes, but then I also kind of wonder, like, where is that line of, gosh, if I would have been a little more aggressive, would he, the opposing attorney, let me say a little more stuff? Could I have tried to get more in? Or do I just look like a jerk for just being like, oh, boo, every single time,
Right. I know it's a balance, right? It's a balance that we also have to realize that the prosecution knows what the defense is doing. And if it's something that they can come back and redirect on, that we just have to stay calm. We just have to be able to present the information that is there, not change anything, not let them trip you up, not let them try to take you down a rabbit hole that would lead them to their narrative. So it's definitely a challenge. And for people that have testified, they understand that challenge.
Yeah. And I think it's always good. And being more seasoned in my career,
Mm-hmm. Right.
to have more of those conversations with the attorneys you're working with, because they can save you on a redirect. So have those conversations. Like, if you see me going, but, and I keep getting off, I'm like, please make a note of that and try to loop back around to that when you get to ask me questions again, so we can clarify that stuff.
That's right.
Trial attorneys, this is what they do. They're really good with a lot of that stuff. And that's why I'm like, I feel like the failure is if you just get into that yes, no zombie mode, then the lawyer, unless you've clearly talked about something and now you've kind of circled into something you shouldn't have said, unless they're really familiar with the data, they might not catch it and they might not come back around to it.
Right. And I would say back 20 years ago, when this, testifying on digital forensics, digital evidence, digital artifacts, there were defense would ask minimal questions because they didn't really truly understand the evidence. They didn't really truly understand the artifacts that you were speaking about. So they also knew that if they ask you too many questions, that it could mess up the narrative or the strategy that they had for their defense.
Right. And remember, in part one of this episode where we were talking about opening statements, the defense counsel did say, like, my, what a technical marvel. It definitely indicated it was new.
Right. And he also said, and good luck. Like,
yeah.
Hey, we're all going into this in a very narrow minded misunderstanding of what we're about to talk about. So sure, absolutely.
Should we wrap it up? Any final thoughts, Becky? Do you want to tear me apart? Tell me how bad I did?
No, I read through the script. I felt like it read really well. I felt like you used good analogies as you were explaining your terminology, especially back then when it was very new. Obviously, I didn't hear or see the tone, but I felt like the questioning led you to be able to answer the questions clearly. And if it was somewhat confusing, it was likely meant to be confusing. So no, I feel like you did a good job. And I always say, if you ever have an opportunity to go watch someone testify on digital forensics, then you definitely want to take that opportunity, because it is interesting, because digital forensics is everywhere. Digital evidence is everywhere in anything that we touch on all cases.
Yes. And so much opportunity to do that now, with so much state court being broadcast live on TV, the internet, court TV, all that sort of stuff. No cameras in federal courtrooms yet. You can watch it. And when I'm always like, well, don't pay attention to the news, that is different than watching actual testimony. You can learn from watching actual testimony. And we could do a whole different episode on that, so I won't go on to that. But like, listening to the news and reporters say stuff is different than watching and listening to the actual testimony, whether it's live or you're looking at it years later.
Yep. And that is so true. And some of the episodes that we plan to talk about is other forensic examiners' testimony in digital forensics. And there's some great ones out there.
Yep. And the only people we're going to beat up on this podcast is ourselves.
That's right.
Not throwing shade at anybody else.
No, never. And we will definitely bring to light some very good people who testify and ourselves, right? We've been through those challenges. You've just proved how to truly produce a good expert witness testimony in this case. So, do you have any final thoughts?
No, I think that's good. Thank you for your kind words.
Absolutely. All right, everyone. Until then, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you've enjoyed this episode of Parsing the Truth One Bite at a Time, please head on over to our website, parsingthetruth.com, and click on that donate button and help us raise funds to send one future digital forensic examiner to the IASIS Basic Forensic Examiner Training next spring in Orlando. Thank you.